You may
Morning.
proceed.
Nice to see you. May it please the court. My name is William Hazel. I am here this morning on behalf of the MCI taxpayers in this current appeal. This is from a proceeding before the Appellate Tax Board under Chapter 59, Section 39 of the Commonwealth Statutes. As the court knows from its recent consideration of the Bell Atlantic Mobile case and its consideration a couple of years ago in the RCN case, under Section 39, the Commissioner is charged to centrally value all of the machinery, poles, wires, underground conduit wires, and pipes of the telephone companies in the Commonwealth. Unlike RCN and Bell Atlantic Mobile, this case does not involve a question of whether the MCI taxpayers are in fact telephone companies. They are. That's been stipulated, and there's no challenge on that front. This case does involve, for the first time, at least since the 1940s, a question of valuation of the Section 39 property that's taxable, and it also involves a number of legal issues. I will speak first to the Commissioner's argument about the proper standard of review under Section 39 proceedings at the Board. I will then speak to the valuation issues, and then two legal issues important to the MCI taxpayers and other taxpayers. Is a single-member LLC that's a disregarded entity eligible for the utility exemption, which we believe it is? And also, when you are applying the utility exemption, should you follow the plain language of the opening paragraph of Section 5 of Chapter 59 and apply the qualifying factors as of July 1, not January 1? So those are the two legal issues for the end. Speaking briefly on the standard of review, as we said, the Commissioner is responsible for valuing all these telephone companies each year. She applies a mass appraisal system in order to make the valuation she needs to make by May 15 of each year. And under that mass appraisal system, it's basically a standard approach. In our view, that mass appraisal system may or may not result in fair cash value as to any particular taxpayer for any particular fiscal year. The fiscal years we're dealing with here are fiscal years 04 to 06, 2004 to 2006. The Commissioner has pursued, both in this case and in other appeals that are pending at the Board, the argument that when the Board considers valuation challenges, either the taxpayer or the community, because either the taxpayer or the community can challenge the certified values, the Commissioner's position has been that the Board should engage only in an appellate review of those values. Traditionally, before the Board, proceedings are de novo. Every issue raised in the pleadings are considered in a full new trial.
But do other statutes, though, have that language about substantially over or lower than? I mean, doesn't that somewhat change the
Yes.
calculus here?
I understand. In my view, the difference with the substantiality language in Section 39 is that if the Board determines that there's only a slight difference in the fair cash value compared to the number produced by the mass appraisal system, then perhaps that slight adjustment should not be made. There is one case, General Electric versus Assessors of Lynn. That was an ordinary valuation proceeding, and only a very minimal fair cash value adjustment was made by the Board. And this court said, in that situation, well, if the fair cash value is different than what the assessor said, even if it's minimal, you have to change it. And I think, in my mind, the only difference in Section 39 is taxpayer bears the burden of proof, as always, but it must show that there was a substantial difference, more than de minimis, more than 1%. Now, what that percent is, I'm not really prepared to speak to, or the cases don't speak to it, but I would say that's the difference. I don't think it changes the entire proceeding at the Board.
But did the Board here find that the taxpayer had met its burden of proving that it was substantially higher or substantially lower?
No, the Board...
They found just the opposite.
Well, the Board...
Well, doesn't that end the inquiry?
Well, I would say then you move to the substantial evidence review of the evidence that the Board considered. In other words, the commissioner does argue that
you have to have substantial evidence in order to show that the value is substantially higher or substantially lower. Here, the Board found that the taxpayer did not meet the burden of proof, so there was no substantial evidence to show that the valuation was substantially higher or substantially lower. End of question.
Well, I would respectfully say that the Board, and I will speak to the valuation issue and move from the standard review, and I would say that on the most important adjustment, because we're talking about a cost valuation, which is the usual way to value utility property. The most important adjustment in this case is the economic obsolescence adjustment. And so the board accepted the commissioner's experts' approach of allowing a 25% economic obsolescence adjustment. But when you look at that, as we say in the brief, and when you look at the key exhibits, exhibits CORM and CORN, you will see that that 25% economic obsolescence adjustment was based on the purchasing history, the group of assets that happened to be owned by one wireless company.
Yeah, but didn't the commissioner invite input into this question, received information from 6 people, and she made a determination that the purpose of, or that the effect of economic obsolescence essentially was standardized between wireless and landline companies. They experienced the same level of economic obsolescence, and so when she took the information from this wireless company, she essentially was applying information that was industry, that crossed the industry, and it was standardized for purposes of both wireless and landline companies.
That's certainly the commissioner's position, but I would respectfully submit that you're talking about a wireless company that has completely different types of property. It doesn't have conduit, doesn't have fiber optic, and importantly, if you look at Exhibit 112,
it doesn't, but the economic obsolescence applied equally to landline company and wireless companies. And did the taxpayer present substantial evidence that methodology was improper?
I believe we did, Your Honor. I believe we did.
And the information that you presented was essentially information that constituted capitalization of income material that's normally used for capitalization of income rather than ad valorem tax appraisals.
Well, I would say 2 things on that. We certainly did, the primary appraisal was done by AUS Consultants, and in that appraisal, the economic obsolescence step was done on a book method or a generally accepted
cash flow method.
Well, it compared, I would not say it was a capitalization of income method.
But it was based on cash flow.
It was based on rates of returns that were being experienced by these sorts of landline companies.
But isn't rate of return the essence of the capitalization of income approach?
It is one of the calculations in the capitalization.
It's the heart of it.
I would say what was not done was the expert did not take the income earnings of these 2 taxpayers and extrapolate it out for a 1-year period and determine returns on income. They did not do that.
They did not do that, but they very cleverly imported some of the concepts from capitalization of income into this approach that they're trying to interpose onto the ad valorem, the third method of valuation.
I agree there's commonality there, Your Honor. I certainly agree there's commonality.
Well, that's what your appraiser was trying to do, was interject a commonality.
He was trying to evaluate the returns that, in point of fact, this property was yielding, and it's woeful. Remember, these companies were in bankruptcy. These companies, like many others, if you look at Exhibit 112, across the industry, the wireline companies, the landline companies, were getting clobbered by the wireless companies, by the competition between the CLECs and the ILECs, and the board acknowledged this at pages, I believe it was 284 to 286 of its opinion.
But that's a cash flow approach to the valuation of the property.
Well, if you can't earn any money with the property, it certainly indicates the value. It is one way to measure the economic obsolescence. It was not the entire valuation approach. It was a cost valuation. And as the Blakely case says, the most difficult step in a cost valuation is the economic obsolescence step. There's no doubt about that. But having said that, I get a little confused or concerned that the board, first of all, excluded our second appraiser's report on the basis that it was a business valuation followed by an allocation to this property that was being valued. And the board member said, that's not a recognized method. Well, in point of fact, the General Dynamics case recognized that method. And this notion that we only have 3 methods and we always must use cost method for utility, that's the appropriate method here. But I make the larger point. It's fair cash value. What would a willing buyer pay to a willing seller? And you should be looking at all of the evidence you could possibly look at to make that determination.
So you're essentially trying to create a fourth value of valuation, or a fourth method of valuation.
I would say the undertaking is a little more demure than that, Your Honor, a little less aggressive. We're simply trying to measure economic obsolescence at the last stage. On the legal arguments, I would say that we've gone through them in the briefs, and I would urge you, please follow the statutes as we always do as written, and I believe on both of those issues, you will conclude that the taxpayer is entitled to the utility exemption for 04 and 05. Otherwise, July 1, not January 1, governs applying the qualifying factors for the exemption.
Thank you, Mr.
Thank you.
Hazel. Mr. Ambriano?
Good morning, Honorable Justice of the Supreme Judicial Court. I am Attorney Richard Shimolinski.
Oh, I'm so sorry. I have you out of order here. That's fine.
Is that all right, Justice?
Absolutely.
Thank you. I represent the City of Newton Board of Assessors, and with me at the municipal table is Attorney Anthony Ambriano, who represents the City of Boston Board of Assessors. We have agreed to split our 10-minute allocation to 5 minutes each. I will be presenting on the issue that the taxpayer, MCI, failed to produce a fixed asset register of what its tangible assets were. And how can you possibly value something if you don't know what it is? The board findings should be vacated because there was no foundation to start a fair market value assessment because nobody knew what the assets were. The second issue I will present is that the board got it right and should be affirmed on appeal that since MCI Metro LLC was never a corporation, they're not entitled to the corporate utility exemption of 59.516 paragraph 1, which would exempt their machinery, expensive switching equipment, the
Do we
amplifiers,
have any
the
past,
routers.
do we
Yes,
have any
Justice
past
Moore.
cases that shed light on that proposition?
RCN.
That's what I thought.
You said
That's what I thought.
you're not a corporation, you're an LLC. RCN, represented by Attorney Hazel, when we were here in 2004, you don't get the corporate utility exemption. I mean, it was that clear cut. It's that simple. And Attorney Hazel's trying to carve out an exception. MCI, the same taxpayer, in the RCN case, submitted an amicus brief asking you to carve out an exception for LLCs.
I'm sorry, the LLC was taxed as a corporation.
Elected to be taxed as a corporation for federal income tax purposes. Yes, Justice. That is
And
correct.
that makes no difference.
No
That
difference.
doesn't
It's
fit
federal-
it within the definition.
It's federal income tax. There's no, in ad valorem tax, there's no check the box option or disregarded entity options. You can't transfer federal income tax code concepts to ad valorem tax issues within our taxing scheme. It just doesn't work. It's erroneous. If I might just
I
get
thought
back
it
to
was
my
taxed
first
as a-
issue.
I thought it was, maybe I'm wrong, wasn't it taxed as a foreign corporation subject to taxation under 52A?
No, this taxpayer was not taxed as a foreign corporation, was taxed as a disregarded entity, and its assets were taxed through its flow-through, through its single corporate member, which is MWNS Incorporated. No question, the incorporated organization deserves and got the corporate utility tax. What is at issue is, does the LLC deserve the corporate utility exemption from tax on its machinery, on its personal property? We say no. The board got that issue right. I mean, the statute itself, the exemption statute, talks about foreign corporation, subject to tax under 6352A. You go to 52A of 63, it defines what a utility corporation is. An incorporated telephone or telegraph company subject to Chapter 166. This entity, MCI Metro LLC, is just that, an LLC. It's not incorporated. End of story. No carve-out, no exception, no transferring federal income tax code into our ad valorem tax statutes. It doesn't make sense. He asked you to do it in the RCN case. You didn't take him up on it. You shouldn't take him up on it now. Now, the lack of a fixed asset list bothers me. If I had to assess what's the value of those chairs and tables, I better know how many chairs and tables are up there and not use accounting, tracking investments under your Book 30s, your SAC books, and your federal income tax books, your Book 10s. Because if we track just accounting numbers, who knows? A couple of chairs might have ended up in the appeals court. A chair might have ended up down at the BMC. They came in asking that the Commissioner of Revenue Central Valuation be completely undone, but they never identified what the assets were. They relied on their Book 30s, their financials, and their Book 10s. And you know what they said about those? Quote, accurate, reliable, separate entities financials are unreliable. We would welcome the opportunity to cooperate in an audit. They testified, both Bernhardt and Bluzak testified, irregular accounting practices in the billions, with a B, billions of dollars. Line costs, quote unquote, $5 billion, and Mr. Bluzak uses the word, quote unquote, fraud. That was their starting point. And they came in not telling us how many tables and chairs. We didn't know if they were located in Newton, Leominster, Boston. We had no idea where they were located. As a matter of fact, in our brief, we give a great example that stands out of $2.5 million in fiber optic cable in Boston, which they reported on their Book 10, their financials for the federal income tax purposes. But it disappeared. It went down to $300,000 on their state return, the Form 5941. And then the next year, in fiscal year 2005, it disappeared altogether. Well, what happened to the $2.5 million of fiber optic cable in Boston?
Mr.
They never
Chemerinsky, I
explained
don't
it.
know what happened to the $2.5 million. I do know what happened to your time. It disappeared altogether. Thank you, Mr. Chemerinsky.
Thank you very much. And now Attorney Ambriano for the second
Sure.
5 minutes. Thank you very much, Justices.
Mr. Ambriano? I know the time is short, but we have read the briefs, Mr. Ambriano.
Certainly.
Talk fast.
May it please the Court, Anthony Ambriano for the Board of Assessors of the City of Boston. I would like to address two issues in my 5 minutes, both issues of first impression. The first discussed somewhat by Attorney Hazel, and that is a very fundamental issue, is what is the function of the Appellate Tax Board in reviewing the Commissioner of Revenue's Section 39 valuations. The Commissioner of Revenue has arguing for a standard that the taxpayer or the municipality must show that the methodology employed by the Commissioner was incorrect in order to get relief. The assessors do not agree with that analysis. Nor, however, do the assessors agree with the analysis undertaken by the Appellate Tax Board. The Appellate Tax Board, in its decision, states that in these Section 39 central valuation cases, the role of the Appellate Tax Board is to initially determine, and that is the words used by the Appellate Tax Board, to initially determine whether the Department of Revenue value is correct. Put another way, the Appellate Tax Board is essentially sitting as a supervisory role and examining what the department did to arrive at its values.
But how should you get relief if you haven't brought an appeal for 2 of these years? Isn't that the case?
That is correct. That's the second issue, and I will certainly address that now. The statute which we refer to in our brief, statutes of 1933, session laws, and I.
The 33 Act, yes, I kept getting
The 33 Act, yes, not the Securities Act, but the amendment to the general laws states that in an appeal, the Appellate Tax Board can either increase or decrease a valuation. And I'm certain that the Appellate Tax Board looked at that in its decision and addressed it and basically said, we haven't found anyone who's relied on that. We haven't found it cited. Nonetheless, the statute is there. The Section 39 procedure mandates that in an appeal brought by a telephone company, it mandates that the municipality be brought in as a party. That has to happen. And given that the municipality is in as a party by operation of the statute, it would just seem to generate unnecessary appeals to have the municipalities file their own appeals from the same central valuation.
Why?
Because under the case is going to be heard by the appellate tax board.
Right?
The evidence is going to be presented to the appellate tax board. There is no reason why a municipality, either in its answer or otherwise, can just plead that on the Commissioner of Evaluation's number is too low.
Well, shame on them. You mean you're not going to come in and test the valuation of the commissioner?
Well, municipalities may or they may not, and they can certainly take the initiative under Section 39 by filing their own appeals. That is an option under the statute.
Would it be the case that the taxpayer's position would for those purposes, always be the same as the city's?
No, not necessarily at all. The taxpayer could very well be arguing for a lower value at the appellate tax board, while the municipalities might be arguing for a higher value,
As in this case.
Right.
as was the case here.
So how can you just stand by?
Well, if
maybe I'm missing something, but
if the appeal is filed by the telephone company,
right?
certainly the municipality has the option
Of filing across
of either filing a cross appeal or doing nothing.
Right.
And I think that very much ties into the first argument, which is what is the purpose of what is the appellate tax board reviewing?
You want to ride the coattails of the appellate tax board is what you want to do.
Well, not in this
Well, it's
particular
not clear
case.
whose coattails you're riding. At least it's not clear to me. So finish. So you don't. You have the option.
Yes.
And what are the consequences if you go one way versus the other? You do file a, let's call it a cross appeal. It's not really a cross appeal, but it's an appeal.
If the assessors were to file their own appeal, that would certainly give them the opportunity to present an affirmative case
Right.
at the appellate tax board.
And if you don't,
And if you don't, nonetheless, the municipalities can participate and show, for example, that with respect to inventory issues as addressed by Attorney Chmielewski, that the Commissioner of Revenue started at the wrong point. They didn't have a proper inventory or a complete enough inventory to value the property at issue.
Well, so I take it then that the consequences of that approach are that you're essentially impeaching the case of the taxpayer, but you're not entitled to affirmative relief under that approach, are you?
Well, I think certainly you can.
On what basis?
Because there are many, many variables in this case.
But you haven't contested the valuation of the commissioner as being contrary to your view, to your interests.
Well, though not contested, certainly we can impeach witnesses from both the Department of Revenue and from the taxpayer.
Yes, but, I mean, if
And-
one doesn't appeal against, never mind, yeah.
and you did that in this case, correct?
We, the Assessors of Boston, yes, participated in each fiscal year that was at issue, presented an affirmative case with respect to each fiscal year that was at issue, even though for the 2 fiscal years, Boston had not filed its own petitions.
And did it ask for any relief?
Yes, the Assessors of Boston asked that the appellate tax board find values in excess of those found, in excess of those certified by the Commissioner of Revenue.
Without filing your own appeal?
That is correct.
I have to say, we often say the issue is novel. This is really novel.
There are issues of first impression, and
Well, I'm
I
not
s-
talking about
certainly, there
first
certainly is
impression.
one.
I'm talking novel. You don't file an appeal, but you get to assert affirmative relief. You may be correct.
Well, the statute does
No,
give,
I understand that you have a right to participate. That is not an issue.
Mhm.
The question is, what's the scope of the right? I mean, if you exercise a limited scope, what are the implications of that? Seems a little at odds with the way we generally look at even an ATB proceedings.
well, a Section 39 procedure is certainly it is a novel type of procedure in which there are multiple appellants contemplated
What's the
under the
purpose?
statute.
What's the purpose of allowing you to appeal then?
Because there may,
Why would a city ever want to file its own petition?
in a case where the telephone company has not appealed. If the telephone company is satisfied with the value,
And you think it's way, way, way too low. They have
Correct.
with it, and you want to come in and
that is correct.
I think we at least understand your argument.
I'm all over. Thank you very much.
Thank you, Mr. Anguiano. Mr. Shapiro.
Good morning. May it please the court. My name is Daniel Shapiro, and I represent the Commissioner of Revenue in this matter. I'd like to start out by saying that the Commissioner agrees with the Appellate Tax Board that the Commissioner's statewide methodology and values for these MCI entities for fiscal years 2005 and 2006 were correct. Where the Commissioner disagrees with what the Appellate Tax Board did was the Board's application of a standard of review for Chapter 59, Section 39 proceedings, as well as the Board's imposition of a 25% additional economic obsolescence deduction for fiscal year 04.
Could I ask you a question about that, which is probably going to be too simplistic, but it seems to me that the reason that you added the 25% economic obsolescence for 05 and 06 was that your expert, and I'm forgetting his name,
Sansusi.
Looked at what the result of his sort of formula was, or model, construct, thereafter, and thought it needed some adjustment. Is that right?
After the 04 was the first year
Right,
in which
right.
Sansusi's method was
And then he's kind of
applied.
assessing how did it work?
Correct. At the end of 04, there was an evaluation based upon input from taxpayers and based upon looking at the model and the method, and a determination was made after considering those factors that an additional reduction, that a 25% reduction would be
So-
appropriate for 05 and 06.
So I guess I'm having a little trouble if that's when he's looking back and he says, you know, we should adjust this. Why would it be incorrect to adjust it for 04 if that's being appealed?
Well, two reasons. First, as I said, the 04 was the first year, and 04 was not performed in the exact same manner as 05 and 06. Sansusi made his recommendation, which was the reproduction cost new with a depreciation deduction, and the model was designed to take into account the 23 FCC property categories. For fiscal year 04, taxpayers had already filed their returns, and they only filed property in 3 categories: poles and wires generally, underground conduits, and machinery. The evidence was that as a result of those 3 categories, they could not use the full method. So what Mr. Sansusi recommended to the department was to aggregate the categories and average them. As a result of that process, the reproduction cost new started out lower to begin with, and the depreciation, which includes physical, functional, and economic obsolescence, was also lower because the useful lives of all the properties were averaged and combined. So as a result, by the board,
Was lower or higher?
the depreciation was higher.
Okay. The ultimate value would be
Yes,
lower.
the ultimate values were lower. The depreciation was higher. I'm sorry. So when the board said we're going to apply consistency, they actually created inconsistency because they applied the 25% from the 05 and 06 years back to a year which already took out additional economic obsolescence. And it's that inconsistency where there was no consistency from that. The other concept that plays into that is, for a valuing authority, what's their obligation? Their obligation is to continually try to improve their method. And the Sandwich case and the law of this court, the decisions, speak to the fact that just because you have improved a methodology in a subsequent year doesn't automatically mean that the prior years are faulted. Now, the board sought to apply additional economics for the additional economic obsolescence for fiscal year 04. But there was no evidence of the 25% because of this inconsistency. No party proved an amount which supports the 25%. The board categorically rejected the experts from the MCI companies as well as the experts from the municipal parties for other figures. So there is no percentage in the record which serves as a basis for that 25% and no substantial evidence. But what the board said was that the commissioner did not quantify that 04 conservative approach. Now, that puts the burden on the commissioner, and there is no burden on the commissioner in this case. There was no burden on the commissioner to prove the value, and the other parties failed in their burden to prove that the value was either substantially too high or substantially too low. And that putting the burden on the commissioner in this instance is where we find fault with the additional deduction for 04 and why that should be reversed. With regard to the standard of review, I think it's insightful to look back to the remedial nature of this statute and why it was enacted in 1915. It was enacted to remedy inconsistent valuations by multiple boards of assessors across the Commonwealth. The hallmark of this statute is equality and uniformity in valuation. Now, the commissioner came to this court in 1954 and said in a valuation appeal that the statute has an arbitrary and capricious standard. The appellate tax board has to determine that the commissioner's values were completely unreasonable. And this court rejected that approach and said there's nothing in the statute that says that. 6 months later, the legislature amended the statute. And that's when the language that an appellant has the burden of proving that the value is substantially too high or substantially too low was put into the statute to cure that defect. Now, this court, in the Sandwich case...
There's a big gap between arbitrary and capricious and what MCI is asking for here. I mean, arbitrary and capricious is essentially, if the standard is arbitrary and capricious, you basically hardly look at it.
Well, the commissioner's position here, as this court referenced in the Sandwich case, is that it's an appellate standard of review, that the board's adjudicatory role is as an appellate court.
I understand that. But what I'm saying is, if you knock out arbitrary and capricious, why do you automatically drop to an appellate standard of review?
Well, I would suggest that the appellate standard of review is, in fact, whether or not any party can establish that the commissioner's method was arbitrary or capricious, and whether or not there's a substantial basis and whether or not the commissioner's values are reasonable.
So what happens if the board finds that the commissioner's values are substantially too high? Then what does the board do? It does its own independent valuation?
Well, the position under an appellate standard of review, the board would look at the commissioner's methodology and determine whether or not there is a flaw in the methodology which cannot allow the commissioner's methodology to create fair cash values on a statewide basis. If the board finds that there is a flaw in the methodology, then the board can calculate values.
All right. Okay, I guess I understand that. So what you're saying, if appellant meets their burden of establishing that the values are substantially too high, isn't that what you're talking about?
Yes.
Right.
All right. Then the board looks at the methodology to figure out whether it's flawed?
No, it's actually the other way around. That an appellant in a central valuation case must put on a case to prove that the commissioner's methodology cannot arrive at fair cash values. That the substantiality aspect there is a qualitative approach. It's not...
I know, but if the taxpayer demonstrates that the value of the property is $100, but it's valued at $1,000 because of the methodology that the commissioner has chosen, why isn't that enough to meet the taxpayer's burden?
Well, I would suggest that the test, the construct for the analysis is for a taxpayer to come in and prove that either the commissioner's cost method is faulty, that the commissioner's either the reproduction cost new is not a proper method, the commissioner did not take enough physical, functional, or economic obsolescence, or in some other fashion.
Isn't that implicit in what what the taxpayer in this case has done? Because you can't prove that the valuation is too high unless you're using a valid methodology, correct?
You can try to contest the commissioner's valuation by showing that there is a flaw, and that's the appellate standard. You have to show that there is something unreasonable in the way the commissioner valued the property. And the reason is that it's a statewide system.
Well, if If the taxpayer met its burden of proof and said that it should be this valuation, are you saying that the
And the ATB agrees.
and the ATB agrees?
So you've proved, to use Justice Cordy's hypothetical, that the real value is 100.
So what's the relief? Isn't the relief that the central valuation is $100? It's what the taxpayer showed?
I disagree with the premise that that's the construct that the board should apply.
Well,
our
let
disagreement
me ask you a
is-
question to see if you can incorporate this into your answer. How is the appellate tax board equipped to make a centralized valuation of property on its own?
Well, the appellate tax board does not have to make a central valuation on its own. The appellate tax board, in an appellate role, has to look at the statewide valuation system that the commissioner has developed and has used to value the property. And that's what the appellate tax board is statutorily authorized to review. And they review whether or not the commissioner's methodology, which the board did here. I mean, the board said, we find the commissioner's methodology to be correct. And they did that by going through reproduction cost new, the economic obsolescence, all of the factors and the floor.
Did they find that the commissioner's valuation of MCI was too high?
No.
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 And that's the problem.
But the
part of the
issue that the commissioner has with the standard of review is that the board said that the way it's going to determine whether the methodology is right or wrong is to determine the value. And that is not the appellate standard review. That is where the board used a de novo review. And it's the commissioner's position that takes what is a statewide valuation mechanism and turns it backwards. Because you're no longer looking at, is this a methodology that applies statewide to come up with a uniform and consistent value? If you just look at one individual community.
What if it's uniformly off the charts and obviously doesn't reflect fair market value?
Well, then the board would make that finding, and then, under Sandwich, then and only then can the board value the property. Then the board determines the correct value.
So the board has to determine whether or not the methodology is, what, correct? What's the right word?
Whether or not the methodology is reasonable, not arbitrary, not capricious, and it reasonably, and the language of the Sandwich case is whether or not it reasonably designed to achieve the statute's goals, which is a uniform statewide valuation of this telephone property.
So what you're saying is you've got to prove on appeal, if you're a taxpayer or a municipality, that there is something wrong either with the methodology or the result that it produced.
No.
Yes. Well, whether there's a method and that the methodology was properly applied. That's the other part of the Sandwich analysis. You have to prove the methodology was wrong or that the commissioner did not apply the methodology the way the methodology was specified.
If you do that, then
Sorry.
then you get into what the appropriate value should be, but you don't get there unless one of those two things is proved. Is that what you're
Correct. That's the commissioner's view of the appellate standard.
I'd like to ask you two brief questions, and I'm going to ask them both at the same time. The cities, the two cities' positions. Number one is, can a city get affirmative relief without filing its own appeal? And number two, what is the effect of MCI's not having filed a form of list?
The commissioner did not take a position at the appellate tax board or in this court on the first issue.
What's your view about it?
The only thing I can add to the dialogue, which is, and perhaps it's a procedural part of the statute that legislation could address. I don't know if it affects the substance of it, but there's a 30-day window for appealing. There is no time that triggers a cross appeal. So if one party files an appeal, you don't have 10 days to file a cross appeal. So
but do you have to file a cross appeal to get affirmative relief?
Or do you have to file an appeal?
An appeal.
Let's assume that there's no
Commissioner did not take a position on that.
What about the failure to file a form of list?
Well, I'm not sure where that issue comes from. In this
Comes
case,
from Newton.
In this case, these taxpayers filed the Form 5941. They presented a list of telephone personal property for valuation. The commissioner valued that list of telephone personal property. At trial, there was a substantial issue as to what was the origin of that list and whether there are other lists or better lists which might contain their property. The commissioner did not
Accepted that.
contest that, the commissioner's position was that we valued an appropriate list of property, and the board found that to be the case.
So because this is a centralized statewide valuation system, it's sufficient for MCI to file its list of personal property with the commissioner as opposed to with the cities and towns?
Yes, actually, that is the requirement. The list is only filed with the commissioner. The commissioner values that list. It's really only as part of litigation that arises that those lists are made available through discovery to municipalities that challenge the commissioner's valuation. Otherwise, I'll rely on my brief if there are no other questions as to the other remaining issues.
Thank you, Mr. Shapiro.
Thank you.